All right, I think we got it. I think we
Oh,
got it.
all right, yeah, awesome. Okie dokie. Well, today we'll be debating that individuals should be able to sell their right to sue to a third party. So firstly, I'll just explain what the policy is. I'll ask whether or not you think that's okay, and then I'll give my arguments.
Sure.
So the policy is pretty simple. It's you could think of it in the same way as someone selling on debt to a debt collector, like banks often do. That is to say, they will present the case that is given to these agents. They'll assess whether or not they think they can win it. They'll offer you some amount of remuneration for the right to sue on your behalf. You'll accept that remuneration minus some percentage that they will make as profit, presumably. And then you go about your separate ways. They go on to sue, and then you go on to have that money. Does that make sense? Is that reasonable?
Yeah, that's kind of what I was thinking was going to happen. Yeah.
Sick. Okay. Well, I'll make 4 arguments. Firstly, why this is a just thing for the state to allow. Secondly, why individuals don't sue under the status quo. Thirdly, why government funding is insufficient and why it has to be a private corporation doing it, as is the thing I'm proposing. And fourthly, how this improves better outcomes for both or for all the parties involved. Firstly, why is this just? As I said before, you can think of it like a debt collector. That is to say, when and we're talking about civil suits. So when a crime is committed against you, so for example, you're in a car crash, that person has harmed you in some way, and thus there is this unspoken thing in the law that they owe you for the damages, pursuant to the fact that you can prove it in a court, and such that the court thinks that is just. Now, what you can think about it then is that there's actually an exchange that is supposed to happen, and the only thing that is stopping it is some bureaucratic red tape. What this proposal allows is to offload the bureaucratic red tape to an other institution that is like structurally very good at doing it, presumably because it's a private company and that's what they've based their business model around, such that the exchange occurs minus some fee for the effort made by that corporation. That is why it's just, because you are owed that money right now, assuming that people assess it to be true. So, second argument, why then don't people sue under the status quo? 2 broad classes of reasons. The first class of reason is that they have an information asymmetry. Often individuals don't know the law to which that they ascribe. So, for example, they don't know in a lot of circumstances that a crime has occurred to them, or that they think it passes the threshold that they should bother suing for it. Secondly, and as a result of that, they often let those things type of slide. Second thing under this is that they're often afraid of going to lawyers, or they're often afraid of going to like the state for like public legal services, because they're afraid that they're going to get ripped off or they're going to have their time wasted. Now, in my system, that fear presumably does still exist to an extent, but it exists significantly less because now they're getting that money immediately. They don't have like the fear of financial liability into the future and a legal suit dragging them into bankruptcy, because mine is like a single transaction. Your system is one that has transactions occur over time. Thirdly, they often don't know the extent of the law. That is to say, when one of these things occurs, they don't know whether or not they should be suing for it. So as I said before, they often let a lot of things slide. And so those are the reasons to believe that there's an information asymmetry between them and the barrier to entry to suing. The second class of reasons is that there's often power and emotional barriers that stop them from suing. So often there's this perception that it's very expensive, and a lot of cases it very much is, because it often leads to the circumstance in which you go into financial bankruptcy. And even if it's not true that you would go into bankruptcy, people feel like they would go into bankruptcy and thus don't do it. Thirdly, there's a huge time sink here. So given the clogging of the legal system, they don't want to waste a significant amount of their time. And particularly given the stress that this is likely to cause, given that they've invested money into fixing a wrong that had occurred to them already. So they've already got the stress of being wronged. Now they've got the stress of going through the court system. That is not something that's going to be enjoyable, and is just and reasonable that they should be able to pay another company to incur that harm for them, which is then a reason to believe that they won't do these things under the status quo. So why then is public funding insufficient, and why must it be a private corporation doing it? Firstly, there's simply not enough money that would be required by the public sector to inject into public legal services to help these people. 1, because it's already a huge expenditure right now, and 2, even if there is enough money, even if I just imagine that there's a lot of money to inject into this sector, a corporation is likely to have significantly higher and more competitive remuneration for lawyers, which means the quality of lawyers in the public sector are likely to be significantly significantly lower. This means you get all of the harms that occur under the status quo of people getting ripped off, people going into financial liability, and people wasting significant parts of their life and time into this problem, which is something that's unfair. Thirdly, even if there is this large amount of money, it's highly unlikely going to be going to the civil cases that this is debated about. It's more likely going to be reprioritized and triaged for things like criminal cases that have much larger media appeal and much larger care from the population, which means that even if you had the money, that money by bureaucratic sensibilities is not going to go to the places that you want it to go. Importantly, even if none of that is true, even if you somehow believe that there is enough money in the public sector, I would also posit that the market forces are likely to be significantly better at it, because it would not be the monopoly of the state, but would be a series of individual vendors that are, one, going to be able to specialize in different areas, two, going to offer competitive rates that which would not occur would you have a monopolistic system by the state, and thirdly, are going to bring about other benefits rather than just the solving of these cases. What are those benefits? This is the fourth and final argument. Firstly, those individuals who are in this circumstance do not get the stress, do not have the time waste and the money loss of this suit occurring, which means that their life is just simply not going to be consumed by the fear of financial liability, which is a real fear for the vast majority of people who are not in the upper classes. Importantly, that gives them peace of mind that does not exist under the status quo. Secondly, this works as a really important flagging mechanism for whether or not your suit is a justified one. That is to say, if you call up one of these companies and say, you explain the circumstance and they say, sorry, we don't want to take on this case, that's a pretty good indicator to you that you actually don't have a case or you don't have an easily winnable case, and thus you should not even bother. Now, while that is also unjust, and I fully recognize that people should get their full remuneration, there are problems with the status quo. Some people will not be rewarded the remuneration that they require. And as a result of this flagging mechanism saves them a lot of time that they would not otherwise be saved. Thirdly, this maximizes justice. It obviously maximizes justice for the person who is receiving the remuneration for having a crime committed against them. That's pretty reasonable, and I think that's something that's uncontrovertible. Secondly, it also maximizes justice for the person who committed the crime, because when a crime occurs, justice is done not only when the person who the crime is committed against, the victim, receives compensation, but also when the person who committed the crime pays that compensation. This maximizes the chances that that person will be paying that compensation, which means they're unlikely to do it in the future. There's a fear that they are likely going to be sued, because you can't just rely on the fact that average people are not going to be involved in the legal system, as for all the reasons I identified before, because now there is a company and series of networks out there that is going to come and get you and is going to make you pay what you're owed. Finally, this also just reduces the congestion of the system in the sense that these companies are likely to be significantly more efficient, they're likely to build rapport with judges, and they're likely to be able to dispense large cases all at once. That is significantly better for the status quo, because it means that other non-civil cases and criminal cases are likely to be prosecuted significantly faster. Those are the reasons to believe why I think this is a good motion, and I'll pass over to you.
Cheers, Liam. I just have one question for you. At the point where courts have the ability, hang on, where am I going with this? I had this. At the point where the victim is meant to be compensated and the perpetrator is meant to be paying them this due, at what point is it justified to have someone who has not been personally wronged in this circumstance, so in other words, a third party, someone who has no moral investment or has no actual significant loss, what right do they have to intervene in this situation?
They do have a loss. So I'll state it more clearly. Person A harms person B. Therefore, there is a debt armed to person B. The corporation comes along and pays person B the crime that would have, the remuneration that would have occurred, sans some fee, which is what you can count as being paid for the stress. Now the corporation is the one that has a harm against them. Now the corporation is the one that's out of pocket. Thus, they are justified in claiming that out-of-pocket expense against person A, in the same way that debt collection works.
Okay, cool. So I'm going to be bringing 2 points of substantive, and I'm also going to be integrating my rebuttal throughout. So basically, I'm going to be going through the purpose of legal recourse and why having a third party involved is principally unjustified, as well as the practical benefits that you get from individuals keeping their right to sue. Okay, so the legal system essentially exists as a function of government to maintain and uphold just and equitable principles. I think that's pretty uncontroversial. So you've got the criminal court, which is designed to protect society from people who threaten its standards, but not to the extent where individuals are punished arbitrarily. And you have the civil court, which is focused on restoring people who have been wronged to the place in which they were before this injustice occurred. So particularly in suits, this is looking like things like defamation or contractual disputes or particularly workers' compensation claims and other compensation claims, like the car accident example you brought up. So basically, the purpose of a suit is the ability to recover damages for a party who has been wronged in order to accommodate for the loss incurred from an injustice. Okay, so why giving a party the right to sue has in no way been wronged undermines the integrity of the system in which this operates, and I'll give a couple of reasons for this. Firstly, it suggests that human suffering and injustice are marketable traits. So it creates a market, essentially, in which those who have been wronged most are preyed upon for potential economic advantage from third-party corporations. So this looks like particularly lower SES people being targeted by big corporations and them underselling their right to sue for some money up front as opposed to long-term payout. So the reason this is likely is because lower SES people, so just for context, this is lower socioeconomic status people, have less access to the courts and legal advice, meaning they have reduced understanding of the types of outcomes of a suit. As a result of this, it is probably likely that corporations are going to take advantage of this to the extent where they can maximize their profit margin. I think it's unlikely that Liam has taken a very charitable look at what these corporations would probably do. I reckon that these corporations are more likely going to give them a flat sum rather than the potential payout that they were going to get less a fee. I think they're just going to offer X amount up front, and then they get the profit of whatever the payout is after the thing goes through court. So what that looks like is people lower SES people will not being in a financial position where they can go through lengthy litigation, and so them taking perhaps a tenth upfront of what they would otherwise be entitled to for the sake of having money in hand, whilst the profit of the company who's taking this on for them is probably more than it ought to be, or more than is probably just in the situation where someone is taking this as a result for you. So Liam tried to justify this by saying that this is a convenience fee. I reckon that they wouldn't even bother with a convenience fee. They'd probably just take the profit margin from underselling these people's legal rights and then just walk off with the vast amount of settlement monies that would come as a result of a favorable case. I reckon that these companies would also probably take the dodgy cases as well, because even in the event of a small payout for the sake of a shit case, it is probably likely that they would make at least some money if there was a settlement. Well, the other thing to note is that lawsuits are generally the last recourse for people in the civil system. That is to say that there are various other steps that people can go through before a lawsuit has to actually be launched. So these things look like mediation and arbitration and stuff like that. So before it even gets to the stage of going to court, it is probably likely that a person would be in a better position to receive more money than if they gave it to their right to sue to a third party who then took it to court. I would suggest that a lower SES person would probably be much better off taking this through the different stages of the court, through mediation, through a solicitor, even if there is a particular distrust for those people, because it is more likely that a settlement will be reached because, as you said, there is a great time sink into lengthy litigation, which means that people are unlikely to want to proceed to court in the first instance, meaning that payouts will likely happen before it ever gets to that stage. At that point, where people have kept their legal right to sue and have used it as sort of a bargaining chip by going through the different stages of the court system, it is probably more likely that they come away with more money than even in the best case scenario that they would have gotten from selling their right to sue in the third party. Now, onto this second bit. It arbitrarily awards payouts to individuals who have not been disadvantaged. So essentially, it takes advantage of the equitable nature of the courts in suggesting that individual human experience and loss is a transferable trait. That is to say, the courts account for suffering on an individual human level, meaning that the person who has been wronged, that loss is calculated relevant to their quality of life, their assets, and the adversity faced emerging from that loss. So two issues arise from that. So changing the party who is suing changes the outcome of that settlement. That is to say, if the party who is suing is not similar to the wrong party in terms of the loss incurred, so that is to say, if, for instance, if you calculate using Liam's model of loss, being that they have paid for the sake of the right to sue, if that is not comparable to what the outright payout would be, so for instance, if say they paid $40,000 and that is their loss, but the actual payout is likely to be $200,000 for the person who was wronged in the first instance, it is unlikely that the court will award that $200,000 outright, because the party who is taking this case has not had that individual suffering, particularly if it's a large corporation. They have not faced that amount of loss. The amount of loss they would probably recoup is equal to that they have bought the right to sue for, at which point there is not a particularly viable financial model, and those people would be better off just not operating in that realm. Secondly, it delegitimizes the court as a tool for justice. So essentially what this means is the court becomes a corporate shill, and that these big corporations essentially just buy out all these different rights to sue because they have the capital to do that, and that it will essentially be bought up by larger corporate entities. So people lose public confidence in the courts when they see all the suits being brought are just owned by these larger corporations. So what this is likely to do is it's actually likely to create an actual secondary market where people buy and sell the rights like shares, because particularly if you have certain justices hearing cases at certain times, certain justices have certain proclivities towards certain areas of law or litigation. That is to say, people will essentially have a futures market for suits depending on who they think will be hearing these cases. And therefore, the rights to sue actually attribute, they actually have their own inherent value. And so people will sort of speculate on what the value of those rights will be. What that means is that it leaves the original wrong party substantially worse off, and it awards payouts to parties who don't necessarily need them. So this creates a clear disparity between the rich and the poor in accessing justice in this front. I hope that's good enough. That's my first point. I'll pass over to you, Liam.
All right, sick. Okay, I'll respond to all of those things. So the first thing you claim is that this is a form of legal recourse, which is a function of the government. I agree it's a function of the government. All I'm identifying is the government has failed there, and thus it is justified that a corporation comes in. The observation I'm going to make here is I'm going to ask you two questions, yes or no to each. The first question is, do you support debt collectors or banks being able to sell debt to debt collectors?
I agree that people should be able to sell debt, yes.
Okay. And do you support the existence of insurance companies?
Yes.
All right. Well, an insurance company and debt collectors both charge a flat rate of which the person gets less than that they would otherwise be entitled to, because the company has to make money, to expedite the process of collecting that debt and righting that wrong. And three, are corporations which do make insurance like a futures market, as you just identified. Do you still support insurance companies?
At the point where people are probably going to be, at the point where insurance companies do everything under the status quo to get out of paying people their full dues. So we see people actually having to litigate those companies to get the money that they were originally promised. I would actually not support insurance companies in those particular cases.
Insurance companies often do pay out, and even when they don't, all you need to go is to the relevant government body and they investigate it very quickly and very thoroughly. I've done this from personal experience, because that is their business model. If an insurance company gets a bad reputation of not paying out, then it ceases to exist because people stop going to it. But my proposal does not even have this problem, because people get paid immediately. Your claims are to say that, firstly, that this says that harm is a marketable trait. There was no inherent harm to that. It was just an observation you made. I agree it's a marketable trait. That doesn't mean it's bad. The next thing you say is that these would be undersold and they'd be targeted people from low SES environments, and they would likely not get paid as much. The first thing I identify is that for literally the 10 reasons I gave in my first speech, people from those environments do not go to the court system right now. They do not get remunerated, and they do not get the justice that they deserve. This is, if anything, an increase from zero to some other money that they would otherwise be getting. That's an instant win for the affirmative in this debate. Secondly, it's really unclear how that's a harm. If people are underselling these prices, that there are two easy mechanisms to fix that. The first mechanism is to have consumer regulations about it, as we do for just about every other service right right now, it's unreasonable to believe that they wouldn't also operate in this market. But secondly, there's also the market forces, which would also identify that if a company is underselling, another company will come along and offer more. That is how competition works in every other domain, and that's how the appropriate prices are met. The next thing you say is that it's a flat payout, as I identified before. That may not always be the market, may not always be the business model of these companies. But even if it is, it's exactly the same as insurance, and it's unclear that's a harm. The next thing you say is, well, they would likely take on the dodgy cases. Okay, what's the harm with that? It's still the court deciding whether or not there is a harm or recompense that is owed. And if you trust the courts to do that efficiently, then it's unclear why that's a harm. The next thing you say is, well, there are going to court is the last step. There are often other steps like mediation and arbitration. I agree. But as I told you in my first speech, one, there's a fear of doing that right now, which means people do not access those in the same way that they do not access the courts. And secondly, it's also reasonable to believe that these companies would also do those steps as well if it could save them money and save them time, because they're a business, they want to maximize their profits. The next thing you tell me is to say, well, there's a difference in outcome because the person who is harmed is not the person who is suing. A couple of things. As I said to your question to me, the company who is suing on behalf of someone else is kind of the same as an insurance company. That company has incurred a harm because they've transferred that harm from the person who it incurred to that company for some fee, which means that they are entitled to that in exactly the same way that debt collection works. If I'm a bank and you're a customer who owes me money and you default on that payment, the debt collector can pay me that money, I can transfer the debt to them, and then they can seek that recompense from you. Exactly the same. There's no principal distinction provided. The next thing you say is that there's likely to be there's less justice occurring. As I identified before, there is justice occurring because it means because there are two components to justice. Firstly, the person who is wronged getting recompense, and secondly, the person who did the wronging is the person paying that recompense. This ensures that system occurs. Importantly, this justice is not occurring right now because the courts are failing people, either through power, either through money, either through the lack of information, or either through the clogged bureaucratic system that we have right now, which denies people the opportunity to get valuations on the crimes that have occurred to them. Your next claim is to say people lose confidence, no mechanism provided, but also the people who would be losing confidence are the people who are being paid, are the people who are receiving remuneration that they would otherwise not have received for a wrong that's occurred to them. That seems like a great benefit to me, and in fact would be an increase in confidence for the criminal justice system that is now providing them justice through this introduction of a free market capitalist business network. The final claim you make is to say, well, this will create a futures market on these claims. You don't really provide a harm to that, but you just identify that different judges will view different cases in different ways. Firstly, that's a harm of the status quo and a harm on your side. Judges are always going to be biased in some different way. We have different ways of regulating that, for example, appeals and also cycling of judges. Secondly, you say this will be a larger divide between the rich and poor. It's unclear how that's going to occur because this is a service that's really available to just about anyone. Like, to reiterate again, all you have to do is say, hey, debt collector company or right to sue company, this thing occurred to me. They'll come and interview. They'll ask you what the facts of the case are, and they'll contact the other person. If they think it's a reasonable case, they'll hand you $500, $1,000, $1,500, however much it is. You go on your day, and then they collect the money from the other person. That to me seems like a really efficient system that decreases the gap between the rich and poor, because now people do not have to waste money on the legal system, which could send them bankrupt, and there's a large perception that it would. I'll pass over.
Okay. Okay, I'm just going to go straight on to my second bit of substantive, which is about practical benefits of why people who, individuals keeping the right to sue is, a good thing. So for the first point, personal vindication. So the awarding of a settlement or suit as identified by Liam is a legal statement to a wrong party of a recognition of loss and suffering and that they were right to fight against an injustice. So this essentially provides important catharsis for this wrong party on 3 levels. So it validates that pain and suffering occurred to that party. It allows them to feel morally vindicated in taking an action, and it gives them security and peace of mind, and as well as financially. So it then gives them a platform for them to move forward. Okay, so why does selling the right to sue to a third party undermine those 3 areas? So why selling pain and suffering creates inherent harms to the individuals? So essentially, the individual then conceptualizes that the fact that a loss occurred to them and was brought up by another party, that party has never, pain and suffering cannot be conceptualized by a corporate body. The pain and suffering to an individual person can only be conceptualized by them, and at which point they put a monetary value on that by paying them for the right to sue those people. It essentially suggests that your pain and suffering only amounts to X amount, rather than going to a court and having you taking it yourself to court and being able to accurately communicate to the court the exact nature of the suffering and loss incurred, and the ways in which that has directly affected you, rather than hearing it through a third party body, which kind of cheapens the moral claim that was brought out by Liam as the purpose for a right to sue. Okay, so on to this second point about cheapening of the moral claim. Essentially, when a third party gives another party when one party gives a third party the ability to sue, it essentially suggests to the wider population, so potentially their friends and family, as well as the wider community, that your right to sue in that particular matter probably isn't as strong as it would otherwise be, on a moral plane, in the fact that you essentially just sold, you traded off your right for a small cash benefit. It was unlikely that people were going to view this in a favorable sense, as a result of when you essentially lose the human aspect of the claim of suit. So usually you see a lawsuit as one person who has been wronged by another person and then receiving a legal recourse as a result of that. As soon as you take that human element away from it, the moral claim of of being harmed can't really be conceptualized in that legal sense. And this additionally creates self-conflict and doubt for the people who have sold their right away, in the sense that they may believe that in the future, they may believe that they were shortchanged and that they actually should have just taken it themselves. And they will always be in that consistent cycle of being did I make the right decision? Did I not make the right decision? I'll never know because I wasn't the one to take it to court. For just some rebuttal about your case in regards to the examples between insurance companies and debt collectors and that sort of thing. The reason why that wasn't a particularly convincing comparison is the fact that these companies are probably consistently made up of lawyers, right? You would assume that a legal agency would be made up of people who are experts in the law. This means that these people would probably be experts in the ability to create loopholes, as well as to manipulate the legal system. As you said, these people are designed to cut through bureaucratic red tape. So what that means is that people who would expect some greater payout would then be immediately sort of cut out by whatever contract or retainer they sign at the beginning, because these people are designed, these corporations are designed to keep the most amount of capital and the most amount of profit possible, which means that these people will have they won't have a strong ability for recourse if these people happen to screw up their case potentially. What that means is that even if you get a small payout at the beginning, I've totally lost where I'm going with this, to be honest. Yeah, I'm all over the place. I think I'm just going to pass back to you to conclude, because that's my case. It's not particularly good. So just.
That's all right, dude. Well, I'll respond to those. So I'll respond to your new stuff first. The first thing you say is that pain and suffering can't be conceptualized. I'm not quite sure about that, because under the status quo, presumably the courts can assess the pain and suffering of the conceptualization of the thing that is happening. Lawyers, like when you bring a case to a lawyer and they turn you away because they don't think you've got a good case, that is evidence that a corporation can assess that pain and conceptualization in terms of the criteria of the court system. It's very easy to know what the criteria of the court system is because you can look at all the previous cases. In exactly the same way that lawyers can do it, this company, which is also made of lawyers, can also assess that criteria as well. Now, you may think that that criteria is unjust, but then you're arguing against the existence of a court system to begin with, which is not something I advise that you do. That is an evidence to believe that there is pain and suffering can be conceptualized, or at the very least can be done to a first degree approximation by assessing the criteria of that court system. The next thing you say is that, well, the practical benefit of being able to sue is some catharsis. That is the first part of that they get peace of mind. As I identified before, yes, you get peace of mind under my side of the house because they do not have the stress and financial fear of going into bankruptcy. And secondly, the financial benefit, as I just identified, they're getting that money immediately. Importantly, as you fail to engage with it at any point in this debate, people do not go to the court system right now. They do not go to arbitration, and they do not go to what was the other one you said? Negotiation, whatever it was. This gives them reason to believe that there is no catharsis under the status quo, there is no remuneration, and there is no justice. Mine is the only system that enforces that and allows that to occur by implementing a free market system. The next thing you say is to say, well, there's a less of a moral claim if you're not the person who's been harmed. That's also not true, because we don't say there's a less of a moral claim when a lawyer is arguing for you on your behalf. We do not say there's a less of a moral claim when an insurance company argues for you on your behalf. And we do not say that there's less of a moral claim when police enforce the laws on your behalf so that you don't have to. That is the conceptualization of wrong, and that is the evidence to believe that a moral claim is not something that is assuaged just because it is sold away. Importantly, that moral claim is actually immediately fulfilled when that company buys that moral claim off of them, and then it just becomes a mere financial claim, which is totally reasonable. It's unclear what the harm of that is. Next thing you say is to say, well, this is not a policy that will be viewed well. As I rebutted before, and will say again, it's really unclear why that is the case. People are already dejected with the legal system, they're already dejected with the courts, and they do not have a system of accessing them, either in the sense that they are information limited or power limited in the sense that they don't have enough money to access that. This means that these are the people who are likely to benefit from them the most, because it's an easy service to access, it streamlines that system, and it gives them that money immediately. Importantly, that instills faith in the system that would otherwise go by the wayside, because this gives them an opportunity to fulfill the justice that would otherwise be failed by the state. Importantly, when the state is failing, I'm totally okay with corporations coming in and fixing that void when the state fucks up. The final claim you make is to say that there's buyer's remorse for people who say, well, should I have done it myself? Firstly, that is a harm that occurs with all expenses. It's unclear why this is a particular one that matters. Secondly, those market forces would make that less of a problem, because if you're afraid that you're you were ripped off or something, it would just mean that you would write a review about that company, you would spread it by word of mouth, and you would never go to that company again. This gives an incentive for companies to make the best product possible and to make their clients feel as safe and happy as possible with the transaction that has just occurred, which means that even if that harm exists, it gets drastically minimized by the market forces. And finally, if there is some real harm where people are not, if there's like collusion in the system and people are being ripped off wholesale, then the regulatory body should come in and fix that, as I advocated before and as occurs in every other industry.
Just to respond to some of your points about lower SES people not going to courts in the first instance, what I would suggest is that at the point where you have people who are like specialist lawyers and they advertise in the same ways that these people would probably advertise, and you have those sorts of guarantees where it's like the no win, no fee. You see like Slater and Gordon or like Gerard Malouf and partners in the status quo where you have outlets like those, in the same particular sense where you might not receive, well, I would say that free legal services or the ability to have free legal services is a form of free remuneration that already exists under the status quo. And it was unclear why getting a small amount of money up front was any better than like a comparison to a larger payout where even if you lose that case, you don't actually have any expenditure. And so under the status quo, it was sort of unclear why these debt collecting or like these sue for you agencies were going to be any more effective in drawing in people when you already have these sorts of incentives in place under the status quo. Additionally, we already have competition and consumer protection for people who have been wronged by lawyers in like the legal system as is. It was, yeah, I don't know where I'm going with that. Yeah. Okay. Just to summarize my case, Liam has given you a world in which third-party corporate entities are going to be sort of underselling your right to be able to seek legal recourse on your behalf. What that means is that individuals are ultimately going to be worse off because their own personal moral claim to those to that money is undermined. The pain and suffering that has occurred to those individuals has been nullified, and the security and peace of mind that you get from going forward in a legal claim is sort of like thrown by the wayside. So what has my case offered that Liam's case has essentially sort of not covered? Not much, to be honest. Just to try and clarify what I meant by the human suffering and injustice as marketable traits. At the point where the human suffering and injustice faced by individuals is something that is worth money and that companies are willing to buy up and sort of bid against other people for the people who have experienced the most suffering, what that generally means is that it creates like a capitalist value on the amount of pain suffered by a human being. So that is to say that X amount of pain is worth X amount of dollars, and that creates sort of like a hierarchical system in which people who have suffered the most are worth the most amount of money, and that makes people sort of view where they are in like the hierarchy of suffering, and they might feel, I don't know where I'm going with this, to be honest. Just to summarize, Liam has created a great case, and my case has been sort of dog shit. So I'm just gonna pass over to Liam to summarize his case.
Yeah, I'll briefly respond to those. So the first thing you say is that lawyers in the status quo should fulfill this role. Firstly, they don't get the benefits that I spoke about. So that's time, money, and peace of mind, because you don't get the immediacy under my side of the house. The next thing you say is that there are some companies like Slater and Gordon which offer no win, no fee. That's true. But what happens if you lose is that you get this huge fee and then you go bankrupt. That's not a thing that people want. Importantly, they only pick cases that they're likely to win, which means people who have less borderline cases but are still entitled to justice do not get justice, and that's a harm. The next thing you say is that some people won't use this. I mean, fine, then there's no harm to this. The next thing you say is, but I think some people will use it and it's going to be really accessible for them. The next thing you say is that there's already legal, free legal advice. I gave you 4 reasons at the start of this debate to believe why that free legal advice is insufficient. Not enough money, would be triaged in other ways, is not competitive with the attractive corporations remuneration, which means that they're likely to get the worst quality. And there's also market incentives which improve these things better. The final thing you say is to say, well, this puts a dollar number on pain and suffering. That's true. To the extent that pain and suffering is unquantifiable, it's something the court system already does right now. We already say that you should get this amount of money. We already fine people. We already have those types of financial remunerations. There's no even if that's inefficient, that is the status quo, and it's also something that you're standing behind. It's unclear how this is any different. All this is doing is just putting that dollar amount on the expedience of solving that problem, which I think is pretty justified. And importantly here, the final claim you make is to say, well, people will be valued more if they suffer more. I mean, fine, good. That means corporations will be helping them more and giving the remuneration they deserve. They are likely to be the people who are most vulnerable and thus the people who are most in need of help. And that's something that my system does. Yeah.
I think that's the debate because I've got like shit all else and I just feel like I've just been absolutely battered. So
no stress, man. No stress.
Thank you for my first debate, and the good thing is it's only up from here, right?
Yeah. No, it was a good debate. What we recommend you do, there's like all the other RDs have like debate challenges. Maybe try one of those ones out if you want to have a debate like in the next couple of days. And if you're signing up for the 5K tournament, fucking get in it, dude.
Will do. Cheers for that, bud.
Cheers, man. I'll see you around.